Make leisure lordship.
Yes.
Here, my lord, I beg to mention item number 40 of today's leisure lordship, hearing matters, my lord. My lord,
Yeah.
I am repeating on behalf of the my lord, Nia, my lord. So, may I pray, my lord, at least matter may be adjourned for a week.
On request made by Mr.
M. Fukan, special PP Nia, my lord.
M. Furkan, then a special PPNIA. When do you want?
My lord, next week, my lord, any day.
This the matter after a week.
My lord, yeah. Much of leisure lordship.
Lordship, I'm beg to mention item number 35. Here, a question has been laid down, Your Lordship, as regards whether reference can be made by the reference is made by the learned single judge, whether an application for pre-arrest lies or not when accusation of crime are made against the juvenile justice. Lordship, I need to do some research. Just now, I have come across the last order of this honorable court. Lordship, may I pray some time may be given to me so that
You are appealing for the?
I'm appealing for the state as regards item number 35.
Yeah, I'm appealing for a petitioner lordship. I have no objection. My only prayer is that a date may be fixed. Lord.
Okay. Heard Mr.
B. Bora lordship.
B. Boral and the counsel for the petitioner. On request made by Ms. B. Buyan, then it's special PP
Additional PP for the
Additional
state of
PP.
Assam.
for the state of Assam. When do you want?
In the second week of February.
List on 9th?
Lordship.
9th of February.
Ninth Monday.
Obliged.
May I please? May I please? He's doing it, but may I please, your lordship?
Yeah.
Are you there? No, no, no. There is this matter. You are mentioning that matter, no? My lord, in this matter, I am for the applicant. Oh.
May I please, your lordship? Lordship, I beg to mention item number 17 to 24, lordship. Sir, lordship, my prayer is a matter may be pass over for the day only, lordship.
Also for the day.
The senior standing counsel, Mr. H. Chetia, he have some personal difficulty today, lordship.
For the appellant?
I am for the respondent, lordship.
I'm the applicant.
Okay.
I am the applicant. Lord, I may respectfully submit. If the matter is admitted, then on 9th we can do it and adjourn to 9th so that we may not have the, so that they also can be prepared as to what is the issue. So once admission and then to be heard out. So let it be admitted and 9th we will hear it out. Your lordship may kindly hear it out on 9th. So he will get the adjournment of.
Lordship, today the senior standing counsel income tax department, lordship, he have some personal difficulty, lordship.
No, we don't want to.
Admitting the matter, lordship, hearing is required, lordship. So kindly adjourn for the day, lordship.
No, it's not next day, tomorrow or day after. This week we cannot do it. We have the engagement prefixed matters in the
When
So what I respectfully submit for your lordship consideration is let the matter be admitted and be heard on 9th so that my learned friends can make the submission. We also will make submissions on 9th.
The problem is he's having some objections to the admission.
Yes, lordship.
He wants to have an argument before admission.
I do appreciate his difficulty. I do understand the difficulty, but to make the matter convenient and for us, since we have to come travel, so only admission I'm saying, it doesn't affect anything. And it's a question which is pending in the Supreme Court, the judgment on which we are relying, that itself records the matter is pending in the Supreme Court. So a admission is per force.
Before admission, lordship, hearing is required, lordship.
It's per force.
Objection.
That I can show right now that the judgment on which we are relying, a Delhi High Court judgment, itself records the matter is pending in the Supreme Court. Therefore, it's a substantial question of law. Per force, it has to be admitted. Only the submissions are to be. So I'm not saying them to let them make, we both make submission on 9th.
Yes.
No, lordship, pass over for the day, lordship.
No,
Learned counsel is having some problems.
No, we have
they are convenient date.
we have engagement in Calcutta. I cannot. I have
Any
to
other day,
return.
lordship. Any other day, lordship.
Okay, give a convenient date, we'll fix it on that day.
9th, then 9th.
Okay. Item 17 to
24 lordship.
24, first separate.
But
order.
one thing in that case, since it is being adjourned for 9th, one thing. Let the full submissions be made on that day. Let it be understood that it is not a mirroring or objection to admission. Admission is assumed to be there.
That will fix. On request made on behalf of
S. Chetia, the Standing Council Income Tax Department.
S. GTL and Standing Council Income Tax Department. List the matter on 9th of February, you want?
9th February.
9th February.
It's a Friday where the court will be functioning.
All the matter, all the 8 matters.
On
All the 8
so assumed to be, I know technically it may not be recorded to be admitted, but assumed to be admitted so that we can make full submission.
We'll see what the other party says. On
Let
the-
them understand.
On the next day.
I'm deeply
all
aware.
the 8 matters to be appearing in the list. All the 8 matters appear to be in the list.
On 9th it will be appearing in the list.
All
I'm
separate-
deeply obliged.
Separate order.
Deeply approved.
May prefer. Lordship, we have filed an interlocutory application, Lordship, yesterday. It may come up tomorrow. It is for rectification of typographical error in the order dated 11/1/24 passed by your Lordship.
Okay.
Okay, obliged.
May I please your lordship?
Hmm.
My lord, item number 26, with the consent of other parties, your lordship, matter may be adjourned for a week, your lordship.
Yeah, Mr.
R.M. Chaudhary.
On request made by RM Chaudhary in the council for the appellant. List after 1 week.
Must have.
Item number 41, my lord, and for the appellant, I've sought consent of the other side, my lord. Now, this is the matter where there is a claim of seniority in the rubber board. Now, the analogous matter has been heard by your lordship and the judgment is pending.
Yes,
That will have a,
yeah, let it come up after the judgment is pronounced.
Yes.
We'll list after 2 weeks or 3 weeks. 2 weeks.
as your lordship pleases.
List after 3 weeks.
Much.
On request by the so and so. You're good now?
P. Bharadwaj,
B. Bhardwaj. List the matter after 3 weeks. We are not giving a date.
my lord.
3 weeks.
My pleasure, Lordship. We have filed two analogous retables against the common judgment of this Honorable Single Judge Lordship, where my order has been set aside and direct the respondent's authority to reconsider the settlement of an invalid tenderer. As per clause 10 of the NIT Lordship, which
No, what
was
do you
stayed
want?
by this Honorable Court.
What do you want?
Lordship, matter may be listed on tomorrow, Lordship.
Why tomorrow?
There is some urgency, Lordship.
Monday.
Obliged, Lordship.
My lord, I beg to mention item 31 with the consent of other side. My lord, here, my lord, we still have to obtain instruction and I am praying for some time. Item 31. Come for orders.
Who appears for the other?
Lordship.
Your good name?
D. Roy, Lordship.
D. Roy.
On behalf of T.S. Hajarika.
Heard Mr. D. Roy, learned counsel for the petitioner. On request made by H. Gupta, learned CGC.
My lord,
When do you want?
my lord, after a week, my lord.
List the matter after 1 week.
2 weeks, my lord, after 2 weeks.
After 2 weeks. Yes.
Obliged.
May it please your lordship, my lord, with the consent of the other side, I beg to mention item number 10 of the daily list, my lord. My lord, we have some difficulty today, and my lord, the other side prefers it to be fixed on 8th of February, my lord. I'm appealing for the appellant, my lord.
The other side, you are appealing? You have no objections?
No objection.
Okay, on request made by MS.
R. Barwa, my lord.
R. Barwal, learned counsel for the appellant. List on when?
8th of February. 8th of February. With permission.
May I please, Lordship, I beg to mention item number 15 for adjournment. I have taken the consent of the other side.
You are for?
Appellant,
Okay, on request
Hearing.
made by.
S. Yasmin.
Your lordship, the name of Mr. S. Borthakur may kindly be reflected for the respondent, dear lord.
Yes, Lesman, learned counsel for the appellant. When do you want?
After 2 weeks,
List the matter after 2 weeks. Registry is also directed to reflect the the name of Mr. S. Bhattakur, Learned Counsel, appearing for the respondents in the cost list.
Much obliged. Yeah,
Much
please,
obliged.
Lordship.
Hmm.
Lordship, I beg to mention, for listing up of writ appeal, number 297 of 2021. Lordship, the matter is for hearing. Lordship, may the matter fix on 29th of January?
Tonight is not a hearing day. We'll have it on first.
Nice, Lordship.
Item one for motion. Lordship, in this case, some more time may be granted to file additional affidavit.
How much time?
2 weeks time.
2 weeks for the time is allowed to Mr. J. Laskar, Learned Counsel for the petitioner to file an additional.
Obliged.
List up to 2 weeks.
Item two.
No, sir, the last order did not comply.
Which last order?
The last order, it was directed that the petitioner would pay the amount, 50% of the amount. The guy.
Yes.
Yes, admittedly, petitioner could pay only 65,000. Only Lordship kindly see paragraph number 4, Lordship, in my petition, Lordship.
Yes.
The petitioner stated that though he had paid approximately 1.5 lakhs only, but due to COVID-19 pandemic, the business of the petitioner was completely shut down during the pandemic period. The petitioner is a government contractor and the bills are pending since 3 years. And therefore, the petitioner could not pay the loan amount and it has impact on the business of the petitioner. It is to be mentioned here that he is entitled of rupees 19 lakhs 53,200 only from the irrigation department, government of Assam for the contact.
That we don't know.
Lordship, that has been, Lordship, bill has been, Lordship, given to me, Lordship, 16 lakhs has been granted, Lordship. I can pay, if they want, I can give an undertaking that he can take from the money from government. This is the, I have, we can, and otherwise, Lordship may pass any other, Lordship may give opportunity to proceed appropriate court. I have nothing to, Lordship. Bill has been, Lordship, executive engineer has released, says that 16 lakhs he will release before the month of March.
Have you proceeded with the sale?
No, we have abided by this honorable court's order.
No, we directed you to proceed with the sale, but not to make any confirmation, that's all.
Yes,
We we did confirm it.
You have not confirmed.
No.
But you have proceeded with the sale.
No, that I have to take an instruction now. Because so far, the instruction I that received yesterday that they have only deposited 65,000 out of the total outstanding claim of 17 lakhs 25,000.
This is requesting for payment appeal, not, it's not a question of sanction.
Rate petition pending in the rate petition, that statement is lost. They will pay because irrigation department. I can give volume.
This is a statement of pending liability only.
Lordship.
It's not the question that the department has already granted you the sanction.
Therefore, Lordship, a rate petition is pending. In the rate petition, Lordship, they have this Lordship statement has been given, Lordship. That this liability will pay by the department.
That we don't know.
I have no Lordship. I can pay only because I from tomorrow, Lordship. This is my help. I am helpless, Lordship, as a contractor, Lordship.
Then why did you make that, give that undertaking the other day?
He tried, Lordship. He tried to show some loan amount from his relative, Lordship, but he could not. Only 65,000 for Lordship. 1 lakh he could not manage. It is the situation.
You said 50%.
Yes. 50% he says, Lordship. I said that I will try to
that day.
5 lakhs I will try. But he could not try on pay only one.
You assured 50% within 45 days.
Yes, yes.
That you have not done.
Lordship. Lordship, that is the, I could not manage, Lordship. Lordship, that is the situation. After Lordship, I approached before the authority, engineer, before the engineer, but says that, yes, you will get 16 lakhs. This is your area bill. In the petition, Lordship, I have.
You have no other option but to dismiss.
Lordship, my alternative pairs, Lordship, give me liberty to propose the before, if they will not wait, Lordship. Only 1 or 2 before month of March, Lordship. Government says that, the executive India says that before March, it will pay. If they don't want to wait, Lordship, then give me liberty to.
Yeah,
we have got no objection. How can we stop them?
You have not approached the DRT.
Still, I have not approached that. So give me liberty to approach the DRT. If they are not satisfied, Lordship, before March, I think it will pay a little. Says by government, Lordship. Yeah. And I have paid 65,000, only 17 lakhs, Lordship. I think. Any other Lordship, Lordship. I pay my apology, Lordship.
Yet I think you're trying to play with the court.
Lordship, no, Lordship. If that is Lordship,
That is what we have understood.
we could not manage, Lordship.
It's up to you if you want to approach the DRT or not. But
Lordship.
then we cannot keep this petition.
That's it.
Heard, Mr.
Demand.
Learned counsel for the petitioner.
Yes, Doctor.
Also heard Mr. S. Datta, and standing counsel, Punjab National Bank. Stop. The petitioner availed 3 loans from the Punjab National Bank within bracket PNB, Mangaldoy branch, amounting to a sum of rupees 14,68,849.40. Stop. The petitioner drafted paid an amount of rupees 1.5 lakhs in different installments. Drafted, comma. The petitioner could not pay the interest due to the COVID-19 pandemic and also due to non-payment of pending government bills which were due to the stuff. The PNB, comma, after several reminders, issued a sale notice of secured assets dated 31/10/2023, giving notice to the public in general and in particular to the borrower and guarantor that the secured assets of the petitioner will be e-auctioned on 8/12/2023 on the basis of, within inverted comma, as is, where is, comma, again inverted comma, as is, what is, and within inverted, whatever there is, for recovery of rupees 17,26,076.56. Stop. Being agreed with the sale notice dated 31/10/2023, the petitioner is before this court by way of the present petition. Stop. Para. On 7/12/2023, when this matter was taken out, learned counsel for the petitioner on instructions assured this court that the petitioner would pay would pay 50% of the outstanding dues within a period of 45 days with effect from 7/12/2023. Stop. Stop. Considering the assurance made by the petitioner, this court permitted the PNB, Manguldoi branch to proceed with the sale notice. However, direction was also issued not to make any confirmation till the next returnable date. Stop. Para. Today, when the matter is taken up, the learned counsel for the petitioner, as well as the learned standing counsel, PNB, submits that the petitioner has failed to take steps as assured by this before this court on 7/12/2023. Stop. Para. Considering that the petitioner has failed to keep his commitment as assured before this court, we see no reason to keep this writ petition pending. Stop. Pending, and accordingly, the same is dismissed. Stop.
Liberty, Lordship.
However, liberty is given to the petitioner to approach the DRT if so advised.
Obliged.
If petition is accordingly dismissed.
Item 3.
No. Yeah. He paid. Yeah.
Out of which he paid 1.5, then that, then the total income
Oh, total amount is
16. Pays for parent tree. 4 lakhs first installment, then 9 lakhs, then 3 lakhs. Total is 16.
Manisa, on top where it availed loan, no? It should be amounting to rupees 16 lakhs, huh? Not 14, not 14. Yes. Yes.
May I please, Lordship? Lordship, law and order is the state subject matter as per the 7th schedule of the Constitution of India. It is well known to all. Now, Section 321 of the Code of Criminal Procedure empower the state government to adopt certain policies in regard to withdrawal of cases if it is for the greater interest of the public or, my lord, in order to suppose avoid the social eradication, my lord. Now, pursuant to that, my lord, government of Assam adopted a policy that contained in page 21, my lord. Some of the part of this notification I would like to read out. Page 23, my lord.
23,
my lord. Start from page 20, sorry, my lord, page 21. Page 21.
Mm.
My lord, this policy was adopted on 21st October 2022. Here, my lord, the direction was given to the all public prosecutor, all district of Assam through deputy commissioner, subject standard operating procedure SOP for withdrawal of PT minor criminal cases pending in subordinate courts throughout the state of Assam. With reference to the subject above, I am directed to inform you that the cabinet in its meeting held on 11/9/2020 has decided to go for withdrawal of PT cases by invoking section 321 CRPC, wherein punishment is up to 3 years or fine or both under the Indian Penal Code or any other special act regulation registered up to 14/8/2020, except for cases categorized following heads. These are the molestation, corruption. These has been exempted. Now, Lord, pursuant to this notification, my lord, page 23, certain direction were given. Page 23. And the object of this notification was also cited on top within the column of introduction. There are more than 4.5 lakhs of cases pending in various subordinate courts in Assam, for which a criminal case alone come to more than 3.5 lakhs. The huge pendency of cases has overburdened the court in Assam and has been causing backlog resulting in delay of disposal of cases, which ultimately has financial and social hardship to the litigant citizen. The pendency as on 36/2000 is 3,66,342 criminal cases and 91,385 civil cases. As per National Judicial Data Grid, there are more than 3 crores criminal cases pending across the county. Of late, there has been a call to bring down pendency of criminal in court, both by the center and state, and even the law ministry has drawn a litigation policy and asked the state to review all the pending litigation. Even the issue of reduction of pendency of cases found figure in the discussion in the conference of Honorable Chief Justice and Honorable Chief Minister held from time to time during the Chief Justice conference held on 29th April 2022 in respect in to item number 3. It was discussed that there was an increase in the cases by 54.64% since 1/7/2016 from 2.865 crore to 4.11 crore, whereas the increase of judicial officer is only 16% during this period. Now, my lord, this has been given the certain object behind this introduction of this policy. Now, lordship, based on that, how to deal with the subject matter, a standard operating procedure was laid down that contained in page 25. Page 25, my lord. Now, page 25, my lord, these are the directions which are very important. I would like to read out. Number 1, a general authority will issued by the Judicial Department, Govt of Assam, to all the PPs, additional PP, assistant PP to move appropriate application petition under section 321 CRPC before the respective court for withdrawal of cases covered under the policy pending in their respective district subdivision. Judicial Department shall also forward copies of list of cases with detailed corrections collected from the Honorable Guwahati High Court to the respective PP, additional PP, assistant PP or their every district subdivision. The Govt of Assam in Home and Political Department will issue a general public notice by way of paper publication in leading newspaper about the GOP decision for withdrawal of cases punishable up to 3 years of fine and inform the public to check the details of cases in their respective district judiciary website as well as the notice board to respective district judge CGM. Also specifying that if any of the victim is agreed with the proposed withdrawal, he will be at liberty to file complaint case on their own, to proceed with their grievance, and in appropriate cases, such eligible victim may approach for legal aid before the District Legal Service Authority. The Judicial Department will request all the district and session judge through the Registrar General Guwahati High Court for assistance of the Registrar Court Manager System, Officer System, Assistant, or any other staff to the Public Prosecutor, Additional Public Prosecutor, Assistant Public Prosecutor for the purpose of publishing the list of cases, details of cases for publication in the District Judiciary official website as well as the notice board of the respective court. The Public Prosecutor, Additional Public Prosecutor on receipt of list cases from the GOP shall verify each of the cases to ensure that the case is equally covered under the principal categories of cases to be withdrawn. Now, this is the ultimate direction which has been given. I am straightway coming to page 26, the last direction that which is pertinent, paragraph 8, my lord. Next page. Next page, paragraph 8. The public prosecutor, additional public prosecutor, prosecutor, assistant public prosecutor will take step for getting the list of such cases in their respective district judiciary website with due permission from the respective district and session judge, and also in the notice board of the office of the respective district judge and chief judicial magistrate, sub-regional judicial magistrate with due permission. Now, these are the direction which has been given how to deal with the subject matter. Now, lordship, page 27 is very important, where the objective behind this litigation policy was shown, my lord. Page 27. Paragraph 1. The exercise will reduce the burden of the pendency of the case in the court, within which in turn will facilitate the court to devote more time for serious offences, all pending cases and other cases, ensuring timely justice. It will also provide time to public prosecutor, additional public prosecutor, assistant public to properly prepare the cases and assist the court judiciously. The proposed action will help in decognitions of the jails by way of release of under trial prisoners who are accused in the aforesaid petty minor cases. Now, last one, the proposed action will ensure right to speedy trial as envisaged under Article 20 of the Constitution of India. Now, lordship, these are the optics that have been set down. The question is that, my lord, several directions has been given in this SOP. But in realism, my lord, if we see from the date of 21st October 2020 till date, my lord, the huge pendency of cases which come under this category has not been disposed of. Might be there are different reasons. My lord, the situation I'm just trying to place before this honorable court, 2 or 3 illustrations which I have dealt with personally. Rest I will leave it that how this situation has been dealt with by the trial court or by the public prosecutor or additional public prosecutor. Proceed, just look for an example, page 30. It is one of the example, my lord. My lord, kindly see downside, the PRC was submitted in respect of this case on 28/12/2021. Lordship is got it downside. Now, Lordship, just take the next page. It was disposed of on 11 July 2023, my lord. After 2 years almost. Now, Lordship, reason behind, kindly see down section is 294 to 95, 5 all comes other in this category of this SOP, my lord. Lordship, just take 10 page 32, how this situation has been dealt with and how I was the sufferer personally there. One of the litigant, page 32. Lordship, the matter was taken up on 11/4/2020 for appearance, my lord. There is no necessity for appearance, my lord. Straightway, once this has been placed before the court, immediately PP has to make a submission and that has to drop. Next, kindly see, the trial has begun. Copy, charge, appearance, then dispose of, my lord. Ultimately, I have been compelled to take bail. The litigant writing from this to date, my lord, each and every date, my lord. End of the day, my lord, the matter has been disposed. It has said that it comes under the zone of this policy, my lord, which could have been done at the first instance, my lord. Ultimately, 2 years wastage of time of the court, wastage of the time of the litigant, and goes against the objective that has been set forth in this policy itself. I'm coming to the next, my lord, one of the examples. So, if kindly take a turn, this is also a similar situation which has been dealt with. Lordship, here is a case out of which, my lord, the withdrawal was done on 11/7/2023, page 34, my lord, for a moment. Right side. 34, right side, disposal date 11/7/2023. Now, Lordship, kindly see the same situation which has been suffered by way of page 37, my lord. Page 37. We have pursued it long. Afterward, my lord, the right side column kindly see, Lordship. Appearance, disposal. Ultimately, my lord, it takes a long time, my lord. Therefore, my lord, the kindly see that how this situation has been dealt with by the subordinate courts as much as by the public prosecutor, my lord. This is a serious question. Now, Lordship, another example, because, my lord, the policy says not only IPC, other special cases where, my lord, punishment is up to 3 years, that will also come under the zone of this notification, my lord. Now, food safety and standard case I have dealt with in Amingaon. Now, out of which, my lord, the punishment was up from 6 months to 1 year, my lord. Charge was paid. My lord, we have persuaded that our policy, this policy covers my case. A length hearing took place, my lord. End of the day, my lord, what my lord observation was made, kindly see, page 45. Page 45, the observation downside. Page 45, the provision, last paragraph, madam. Last paragraph. The provision of section 321 of the CRPC mandate entirely that the public prosecutor or assistant public prosecutor must first move to the court seeking its consent for withdrawal from the prosecution. In this instant case, the prosecution side has not made in prayer before the court seeking permission for withdrawal from the prosecution. Instead, the learned additional PP has submitted before the court on 31/10/2000 that she would not withdraw from the prosecution of the case, the being the position the court cannot sue to exercise discretions confirmed under 320 and drop the instant proceeding in view of the aforesaid petition rejected. Now, again, I'm coming to this honorable court by revision. The proceeding has been stayed, my lord. Kindly see, my lord, the situation, how far is danger, lordship, because I'm monitoring this matter, my lord, last, my lord, from the SOP that has been issued on 21st October 2022. Therefore, I have applied for ITI. My lord, page 47. Page 47. Now, lordship, what pertinent question I have put in my RTI paragraph 1, kindly furnish the total numbers of criminal cases that are pending in Assam where punishment is up to 3 years or fine or both under the Indian Penal Code, any other special law, till 3/10/2023. Number 2, kindly furnish the detailed numbers of criminal cases that has been disposed of by the prosecution where the punishment is up to 3 years or fine under the notification. 3, kindly furnish the detailed number of criminal cases which are yet to be disposed of in terms of the notification 21/10/2022. Kindly furnish the reasons of not disposing of the pending criminal cases with punishment up to 3 years or fine both so and so. So and so. My lord, against this RTA, my lord, what happened? It was the cardinal duty that the public information officer has to furnish me the entire detail which I have sought for. Instead of this, RTI has been sent to the all over Assam to the respective courts for furnishing the information, and now the respective subordinate court furnish the information to me, only some of them, directly, my lord. Therefore, the detail which otherwise required for these purposes, that has not been, my lord, procured, my lord. Now, out of this, lordship, kindly see the what is the position which I would like to place the 6 districts information I have collected through this RTI directly. Page 49, my lord. Page 49. This is a compilation part. Number 1, West Karbi Anglong, Chief Judicial Magistrate. Next is Nalbari district. Third is, my lord, Tinsukia. Fourth is Barpeta, Jorhat, and last is Karimganj, my lord. Out of these 6 districts, we can take a picture clear that none of the court is out of pending of the cases which otherwise to be dealt with under the SOP, my lord, 21st October 2022. Huge numbers of cases, my lord. Now, lordship, only some of the example I would like to give. Page 53 for a moment. Lordship, kindly see Dibrugarh case situation. Page 53. Question number 2, 3,544, my lord. My kindly see is a very huge numbers of cases. Straightway, my lord, it comes under the zone so and so, which is clear from this ITI reply. Now, lordship, like this, these are the information, various courts. Lordship, page 71. Page 71, kindly see, this is the information of Hojai, my lord, Sankardev Hojai. It's a small district, my lord, otherwise. But pendency of case 1,989, my lord. My lord, these are the rest information which has been procured through this RTI. We will not go to detail. Now, how to deal with the situation, that is the pertinent question. Lordship, question is that, my lord, I have noticed 2 or 3 facts which is very pertinent, my lord. Number 1, my lord, the list of criminal cases are very clear in each district. There is no doubt to that effect. Now, the approach of the public prosecutor which has to be dealt with, my lord, the only thing is that they have to give their consent, nothing more than, because SOP covers, my lord, there is no need that they have to deal with in a individual to individual case. Now, my lord, because of this pendency of cases, come the poor people how being the separate, they come from the village, pass the entire day, wait for, my lord, their turn, take a bail. Then again, my lord, that situation will develop, which I have already referred in 2 or 3 cases, my lord. End of the day, my lord, when this matter would be disposed of, nobody knows, my lord. Ultimately, it frustrated the basic object of the SOP dated 21st October 2022. It served no purpose. In my view, my lord, what it is necessary, what I'm suggesting at this moment, my lord, that respondent number 1 is the political home and political department, and respondent of the Registrar General, Guwahati High Court. At this moment, lordship may direct them that within 6 weeks, they have to deal with the subject matter, that whatever the pending cases come under the zone of this notification, that has to be disposed of, because they need not to that and submit a compliance report before the honorable court on next date.
Let us see who appears for respondent 1. Yes, you have any instructions?
No, my lord, we'll seek the instruction. It is not that nothing has been done, my lord.
No, it appears nothing has been done.
It's done, my lord, but the thing is happened, in fact, I said, my lord, I got some personal cases. That has been already been withdrawn. It is not that nothing has been done, my lord.
It has been done, but it is taking time. That is an admitted fact. So I'll seek the instruction.
SOPs of 2022, isn't that?
Yes, my lord.
Of 2022, more than 1 year.
That's true, my lord. My lord, one thing is very important, that since SOP, lordship, the thing is what in wrong dice it is moving, lordship, and just maybe because it's a PIL, my lord, it's a public interest. My lord, in my view, SOP object was that the list of the cases that has to be disposed at one shot.
Yes.
Not individual one by one, my lord. But that instead of following that procedure, my lord, the thing is now running that individual one by one cases that has been dealt with. Now, sometimes that SOP are not in their head. I have found it, man, personally. Now, sometimes public prosecutor doesn't have that SOP, my lord. Some they could not understand whether this comes within the zone of this notification or not. They confuse, my lord. Therefore, my lord, it required assistance. The assistance must come from the top of the district judiciary, my lord. Then the district judiciary, honorable district judgment, what can do, my lord? That because under his jurisdiction, whatever the cases come under this under this SOP, that has to be shortlisted, man. Already shortlisted, again, that may be updated. And based on that, my lord, the concerned public prosecutor may be approached. And their views may be adopted. Only consent required, nothing more than that. There's no other thing. Suppose, my lord, out of these, some cases may be confused, 5%, taken that way. That will be segregated, my lord. Then 95% can be dropped. There is no dispute to that effect, my lord. Lists are there. Only one attempt is required. Common attempt is required, my lord. That's why what I'm saying, my lord, let's make a new beginning in this new year. People should not be sufferer. Response number one, my land is correct. Some cases has been disputed. This process will endless process, madam. That's why it is required immediate and urgent action. It is otherwise wasting the
instruction, my
let it will waste the honorable time of the court, my lord, subordinate court. That's why, my lord, respondent 1 and 2 take a joint endeavor. They may take a policy that whatever the cases are there under the line, that has to be dropped in the light of this policy and submit a compliance report, my lord. What is wrong with that? That is my humble submission.
Yes, Gupta, Das.
So far as the issue is concerned, my lord, the questions raised has got importance.
Yeah, that is what court is taking a serious view of this.
Yes, my lord, the issue is important. If those cases can be disposed of in the present day pendency situation, nothing more likely than that. One aspect is that, my lord, in October 2022, the scheme came and the pages shown by my learned senior in page 33 onwards, it shows that yes, after coming of the scheme within July, June, they have released some persons, but the actual data, how many has been released and how many are there, cases are pending, it has to be ascertained by the state government. But at the same time, it is also true that it's a continuous process, my lord. Cases will be closed and again more cases will come. It's a continuous process. So, my lord, mechanism has already been set in, SOP has already been issued. If that is followed by the state government, then, my lord,
Serve the
will come
purpose.
to a, nothing new is required to be done. Your lordship only has to monitor whether that SOP has been followed or not.
But petition in person. Issue notice. Mr. N. Das, the government advocate, appears for the response number 1. And Mr. H.K. Das, the standing counsel, Guwahati High Court, appears for response number 2. Stop. Mr. N. Das, the government advocate, prays for some time to enable him to receive instructions. List the matter on, when do you want? I'll give you 2 weeks time.
After 4 weeks, my lord, there
No,
are many
not-
districts are out there, man.
Yeah.
The information regarding around 35, 36 districts.
24th. Okay. 28th February. By that time, we require something.
I'll file.
Lordship, one observation may kindly be given. It will help. Again, come instruction again. Endeavor would be made by the both the respondent to comply with the SOP and submit report on next date fixed, madam. That will help, madam.
And endeavor should be made.
I'll come with the proper instruction, man.
1 and 2. To comply with the SOP.
Dated 21st October.
Page.
Madam, page 21.
SOP dated 21st October 2022. Issued by the Secretary to the Government of Assam Judicial Department.
And submit compliance report, madam.
And submit compliance report.
Please, on the next step, my instruction will be filed to an affidavit, man.
Yeah,
Whatever, my lord,
Exactly what
there-
is happening, my lord.
We'll s-
Because on the next step matter, it not be possible to
Not-
file the compliance report,
not-
my lord.
Not compliance report,
That is,
to comply with the SOP.
deeply.
Item 4.
It's also a very serious issue, little bit time traveling. Lordship, the issue pertain to victim compensation scheme 2012, my lord. No, no, I'm just giving the background of this, my lord, situation which is otherwise relevant in this present scenario. Lordship, 2009 brought a massive change in the criminal law, my lord, especially section 357, my lord. Now, Lordship, we know it well. 357 is ultimately provided the compensation to be arranged by the wrongdoer, my lord, and it would go to the pocket of the victims. But it felt necessary that that amount may not be sufficient. That's why, my lord, 357A has been brought. Out of which, my lord, the state and central government has taken responsibility that in case of criminal cases, if suppose certain persons are being sufferer, then their responsibility would be taken care of by the state government or the central government. Now, based on that, my lord, that amendment, the Honorable Supreme Court also intervened and this matter has been taken care of. And ultimately, my lord, October 2010, my lord, the various states of our country has adopted their own policy. But their policy was basically in the light of section 357A. Now, in the light of that, my lord, Assam government also adopted the policy that is Assam Victim Compensation Act 2012. My lord, that policy contained in page 23. Page 23, my lord.
This one, I think, government has released some amount, isn't it?
Dr. I'm appearing on behalf of the respondent number 3.
Yeah.
In
that-
fact, in the month of September, July, Your Lordship, last year, I'm placing that document before Your Lordships. In the month of July last year, an amount of 9 crores has been sanctioned
Yes.
to the respondent number 3.
Mm.
And in terms of that, the FOC has also been issued by the finance department, and accordingly, the respondent number 3 has also disbursed the amount to the respective DLSAs. However, with the contentions which my learned friend is making, I'll naturally have to get a little bit of instructions on that. But this is just for your lordship's notice that this amount has already been released by the government of
No,
Assam.
government has released, even the district legal service authority,
They've been, yes, the SALSA has already disbursed the amount to the respective DLSAs.
that
Your
has
Lordship.
been
Has been-
released.
yes,
My
Your
lord, the issue is not that, my lord. Issue is something different, my lord. This is the procedure, my lord. Everybody knows to that effect. There is no. Now, lordship, there are 2 or 3 elements are very important to. Otherwise, my lordship, if lordship will not intervene, my lord, the ultimately the victims will be sufferer at lot, my lord. Lordship, just look for a moment, my lord. Page 24 of the scheme for a moment. Certain other issues are there, my lord. Lordship may kindly look into that whether these deserve certain merits or not. Page 24.
Mm.
Now, here the my lord, column 3 covers victim compensation fund. Here, my lord, column 2 clearly indicates the state government shall allot a separate budget for the purpose of the scheme every year. 2 elements are important, separate budget and every year. It is their own condition that has been laid down under this scheme. Now, lordship, in realism, that has not been acted upon. Lordship, kindly look into page 27. I have put certain query from RTI to the Assam State Legal Service Authority. The queries, my lord, kindly provide the details of total victim compensation fund allotted to the Assam State Legal Service Authority for implementation of the Victim Compensation Scheme 2012 till 31st November 2023. Kindly furnish the detail of the Victim Compensation Award liable to be paid under the Victim Compensation Award in respect of all district of Assam till 31st November 2023. Kindly furnish all the details of the proposals sent to the government for disbursing the amount under the victim compensation till 31st October November 2000. And kindly last question, provide the details about the amount granted against such proposal till 31st November 2023. Now, pursuant to that, lordship, the information which I have received that contained in page 30. Lordship, kindly see the situation. Page 30, lordship, From 2012, certain amount were disbursed. Up to column 8, there is no dispute with that effect. Now, Lordship, kindly note down 9, 10, 11, nil. Not a single penny that has been released. Question is that is it in terms of or in consonance with the policy which they have framed in 2012 where it is stated separate budget every year. They failed. Now, Lordship, kindly see page 32 is a very mind-soaking situation, my lord. Page, page 32, start from page 31, my lord. This is one of the case Lordship may take up Sirang Kazalgaon. Lordship, here it is stated, point number 2, details of the victim compensation award liable to pay and the victim compensation award till 30 years enclosed so total numbers of victim compensation award given to the victim till
You're
to the-
reading from?
my lord, page 31, column 2, RTA information, page 30. Sorry, my lord, page 31, sorry. Page 31 and point number 2, my lord. Page 31. Total numbers of victim compensation award given to the victim till year 2020-18. Point number 6, detail of the total number of victim compensation award to victim till 30 November 2020 under POSCO Act 11, Omen victim 5, victim of rape and murder case nil, victim acid nil. This is the detail they have been furnished. Now, Lordship, page 32 is showing the position. Lordship, kindly the first case is 2018. Inquiry case number 4/2018. Lordship, case number 1. Now here, my lord, it is the total number of case 63 from page 30 to 34. There are 63 cases. Out of which, my lord, kindly see that only 5 has been paid, which is less than, my lord, 10%.
Okay, that will see. Third petition and person. Issue notice. Who appears for finance? Home and political. Mr. D.K. Shamaldan, additional senior governor. Appears for respond number 1. Mr. B. Google and the standing council finance department appears for respond number 2. And MS
R.S. Chaudhary.
R.S. Chaudhary, standing council,
Not.
Assam State Legal Services Authority. Appears for respond number 3. So, respondents are directed to file their respective affidavits. This is the matter after 4 weeks.
Well, Lordship fixed the date on same date, 28 February 2023, 24, same date.
Okay.
Lordship, direction may given to the final, endeavor may be made to, my lord, release the outstanding dues, my lord. It will,
They've released that much.
no, prior, my lord, there, since 2014 cases are pending, my lord.
That we'll see. Let the affidavit come. After
Okay.
that, we'll see.
Right. Now, Lordship, only second issue is also important. Lordship, I have given one, my lord, that here, my lord, direction was given in 2015. Paragraph 2. A copy of the Central Victim Compensation Fund Scheme guidelines is enclosed. You are requested to modify your state victim compensation scheme suitably. So therefore, in the light of this direction 2015, Meghalaya, Telangana, and all state government has, my lord, modified their, my lord, scheme in the light of, my lord, Nirbhaya Fund and other thing, my lord. But till that, my lord, state government has not, my lord, altered the position. The same 2012 Act is running on. Only in 2019, they have only enhanced the certain figure, which is otherwise also less than other states, my lord. Now, a direction is also required, or Lordship may constitute a committee or, my lord, any representative.
No, that is why, Mr. Chamaria, what we'll see, let us see what the affidavit say. After that, we'll pass up.
Man, I just go through that.
Obliged.
Item 5.
Lordship, only humble prayer, my lord. Item number 44, Lordship, just it's a small issue, my lord. I mean, percentage, so item 44. My lord, here, my lord. 44, my lord. My lord, I would like to implement here, my lord, the matter pertain to, my lord, sumoto cognizance has been taken by the in respect of the issue connected to the prisoners, my lord, rights, my lord. Here, my lord, I have certain also, my lord, was to say, Lordship, can you see for a moment the order dated?
No, you can't jump like this.
Man.
You wait for your
Man.
turn.
May please, your Lordships.
My lord, an order taking positive symbolic possession of the properties of the petitioner by the bank that is under challenge. That your lordship will find at page 124, but prior to that, my lord, I'll implore that your lordship may kindly come to page 32. That is the demand notice.
30?
Page 32. This is the notice to borrower under section 13(2).
Hmm.
By this notice, the demand was made of certain amounts, saying that, my lord, I have become my loan has become NPA, and therefore a certain demand was made. Now, my lord, challenging this notice, demand notice, the petitioner approached this honorable court earlier. The order passed in that case, your lordship will find at page 76. Same petitioner, 76. Now, the case in the case of the petitioner in the earlier petition was that subsection 3A of section 13 that has been breached, and therefore that notice is not sustainable. Now, this honorable court passed the direction. That direction your lordship will find if your lordship comes to page 79. That is the effective part of the order. In the second paragraph I'm reading, in the peculiar facts and circumstances of this case, instead of exercising extraordinary jurisdiction of this court under Article 226 of the Constitution of India, which may entail disputed questions of facts that are raised in this petition, including the question whether the bank has rightly declared the account of the petitioner as NPA or not, it would be appropriate to relegate the petitioner to file a further detailed representation, because earlier representation was filed, that was not considered. That was the requirement of section 13, my lord, subsection 3A. As provided under section 13(3)(a) of the Surface Act, and the same shall be considered by the respondent bank as provided under section 13(3)(a), keeping in mind the proviso of the said provision, and pass a reasoned order within a period of 2 months from the date of receipt of the certified copy of this order, and the same may be communicated to the petitioner. It goes without saying that the notice under section 13(2) dated 2/5/2022 shall remain as it is, and only after considering the representation that may be filed by the petitioner as per this order, if any further proceedings are necessary as contemplated under the Surface Act, shall be taken by the respondent bank. So pursuant to this order, we file a detailed representation again. That representation, your lordship will find, my lord, at page 81. Now, without disposing this, my lord, this representation, now the impugn order has been issued that your lordship finds at page 134, annex 124, annex 13, page 124.
Hmm.
So this is the order impugned in this writ petition.
This representation was not disposed of.
No, my lord, that is my case. Therefore, my prayer would be, my lord, your lordship will issue notice to the bank, but they don't have a, my lord, standing counsel. And
Which bank is this?
Bank of
Bank of
Baroda.
Baroda.
My
They don't have a standing.
They don't have a standing counsel.
Okay, heard Mr. M.K. Chaudhary, Leonard Senior Counsel, assisted by Mr.
RJ Das.
R.G.
R.J. Das.
R.G. Das. Then a counsel for the petition. Issue notice. Petitioner to take steps for service of notice on the
Two respondents only, my lord.
on the respondents one and two. By registered post, AD within 1 week from today. Stop. Till the next 1 week from release the matter after we give a date.
Your lordship may.
It will be better. Today is 24th. 1st March. Release the matter on 1st of March. Till the next suitable date. Comma. The position notice dated
12/1/2000.
2024, issued by the authorized officer of the Bank of Baroda, main branch, Guwahati, shall remain suspended.
Highly obliged.
Item 43 from supplementary list.
May I please, Your Lordship? Same
My
response.
lord, on the last occasion, my lord, the direction was issued to see whether there is any possibility, my lord, to accommodate the petitioner at the place of posting which she is desiring.
Mm.
My lord, I am placing the instruction, my lord, dated, my lord, 3/1/2024. My lord has got it. Next page, my lord, 3/1/24 is the instruction, my lord. Not instruction. This. 5/1/24, my lord, is a letter dated 5/1/2024, my lord. No, next page is the instruction. Paragraph 2. Lord, may I read that? Correct. Second paragraph, my lord.
Mm.
As per para 27 of the ROI 1 of 2016, premature posting may be considered after 18 months of tenure in organizational interest, whereas the petitioner has completed only 6 months tenure at new place of posting as on date. Further, the petitioner has already been given assurance to apply. Petitioner has already been to apply spouse posting after completion of the tenure at the present unit. As per para 15 of the ROI 1 of 16, tenure of regular posting is of maximum 3 years, whereas Rifleman P.K. Mishra, husband of the petitioner, is already posted with headquarter IGAR with effect from 13 May 2022 and likely to be completed his normal tenure by May 2025. Therefore, consideration of spouse posting in the mid of the tenure and also the vacancy of the IA at headquarter IGAR is not available at present, hence not feasible due to administrative constraints. However, it is suggested that spouse posting of the petitioner may be considered prematurely on completion of normal tenure of her husband to such LOC where both posts, that is dark runner and IA category, are available so that they can avail spouse posting concurrently. My lord, this was at the instance of the honorable court, my lord. We have explored the possibility whether she could be accommodated or not. But my lord, the department, my lord, has suggested that only after the normal tenure of his husband is over, my lord, we can again consider for spouse posting. But my lord, due to administrative exigencies, presently the post of IA is not available. And my lord, what is under challenge before this court was the order passed by the administrative tribunal, where my lord, the impugn order at page 88, my lord, will peruse, my lord. Page 88, Section 9, my lord, was the order impugned, whereby the authorities has rejected the request for consideration of the spouse posting of the petitioner. My lord, challenging this order, my lord, the petitioner approached the honorable tribunal, and the tribunal dismissed the case, my lord, and now they are before this, my lord, court to challenge the order. Now, may I read the, my lord, the order which was impugned before the Central Administrative Tribunal. My lord, page 88. Paragraph second onwards, I am reading. It is once again informed that you have availed approximately 19 years of good location, 19 years of tenure at good location out of total 26 years of service carried, and also consequently avail compassionate ground oblique spouse posting for the last 19 years since 2003, including 11 years in hometown, that is Agartala. And my lord, thereafter, on paragraph 5 and 6, I am reading, my lord. As per paragraph 20 of the ROI 1 of 2016, spouses, those have availed more than 3 tenures of spouse posting, should not be considered for compassionate ground and LLP at the cost of other deserving cases. You have already availed 3 spouse posting tenures. And in paragraph 6, my lord, also you have already availed 2 compassionate appointment and 3 spouse postings as per para 46 of the ROI 1 of 2016. An individual can avail compassionate ground posting only once in his or her entire service career, including last leg posting, whereas the request for the second compassionate ground posting may be considered in case of person who has completed 30 years of service and availed the previous compassionate ground posting 7 years prior to present request. In view of the above, your request for fourth spouse posting at HQ IGR East is not feasible due to policy as well as administrative constraint. You are advised to apply the same after completion of normal tenure. Now, my lord, after the rejection of the case by the learned tribunal, the petitioner is serving at the new place of posting. Already 6 months have, my lord, gone by. And my lord, the findings of the tribunal, if I may place, my lord. Page 24, my lord. Page 24 is the findings of the tribunal. Paragraph 9, my lord. It is further noted that the applicant had repeatedly approached this tribunal, challenging the posting order on different occasions, at least 3 times, basically on spouse ground, and retained in the earlier posting, somehow either by the interim order or order of the respondents, and again has come before this tribunal on spouse ground, which was specifically rejected by the respondents with a reasoned and speaking order, which she never challenged. Therefore, we do not find any reasons to entertain this way. So, my lord, nothing survives, my lord, because so far as the exploring possibilities, my lord, we have explored, my lord. It is,
Have you given him a copy?
yes, my lord.
I have,
I have given the,
Lordship, what happened after joining in the new place of posting, since her joining, she has been suffering from spondylitis and other related ailment, your lordship. And if your lordship may kindly go through page number 93, it is the medical document where it is stated that a doctor has advised that future advised to stay in hot and warm place. Now, my prayer is that if spouse posting is not it's not cannot be given by the respondent, so I pray that the respondent may post me in any other place where this medical facility is there, where the climatic condition is not so bad, you know.
Where are you posted now?
Fake Euros in Nagaland,
Oh.
where medical facility is not adequate, Euros. Only unit hospital is there.
no, the petitioner had in fact challenged the order of the tribunal, my lord. Now,
Lordship, in my representation
these
also,
grounds,
I
my lord,
have,
has to be a new ground for challenge.
in my representation also, I have specifically
You can
stated this
approach
thing.
the authorities by making a separate
Representation.
Now
that
she has
can
been in sick leave, your lordship, and she has time and again extended her leave. And now her leave will expire on 4th, your lordship, 4th of February, your lordship.
So you make your representation before, why should we give a direction?
So at least a
If your
petition,
representation is not considered, then you can approach the appropriate authorities.
can be given, my lord. We should give a representation, my lord, because now what is in the challenge is
If your
the,
doctor is prescribing that you should be posted in a hot and warm place,
that the
that is
authorities will consider. my
that
lord.
the authorities may consider provided you make a representation.
your lordship, I pray that she may be allowed to appear before the medical officer to assess her medical condition. If medical officer prescribe that she can go and join there, she has no objection. But the thing is, if doctor say that she cannot be joined,
Medical officer has already considered your matter.
yes.
They may provide a better medical facility also, my lord. We don't know.
No, any other place where this hot and warm place, your lordship. I have no objection. I'm not asking for any spouse posting, but on my health condition only I'm asking. At least this prayer may be considered.
What is under challenge is the order passed by the tribunal, my lord. The prayer made by learned friend is a new prayer, my lord.
No,
which
it's
can-
not a new prayer. Even in my
Separate
original
prayer.
application before the tribunal, I have prayed on medical ground also, Your Lordship. It is specifically stated.
You
in
make
my
a
application.
representation, a fresh representation.
So till that, at least some protection may be given so that,
She is already serving.
and she has been under treatment. She has been doing physiotherapy morning and evening, Your Lordship, 2 times. She has to appear before the physiotherapy doctor. She is in her hometown, Your Lordship.
Where's your hometown?
Agartala, Your Lordship. At least some protection.
What protection should do we give you?
At least till the representation is considered.
No, no. That way you are really extending your leave. This court will be indirectly giving you all the reliefs you want.
My lord, also I have given a chart, my lord, by which from time to time, my lord, the spouse posting was considered. My lord, the chart which I have given by way of a tabulation. My lord, she was every time at Agartala, my lord. My lord, we'll see at column number A for Agartala in 4 years, my lord. In column number C, again at Agartala, my lord, for 3 years. Then in D, my lord, most of the time, my lord, she was considered. And as per the rule, 3 spouse posting maximum, my lord, at column D, E, N, G, she has already been given.
My spouse posting was considered only once in my service career, Your Lordship, and one it was my husband has applied for in 2011. I had applied in 2015, which was considered, and after completion of my normal tenure in 1 MGR, I have again applied for my spouse posting. That was not considered, but due to pendency of my original application, the matter has been stayed, Your Lord, for till 2020, 22 Your Lordship. 23 Your Lordship.
That we can give a direction. You make a representation, it's up to you.
Yes.
So
Then my medical condition may be considered in this case. On this ground only.
with the impaired order,
Page 18, my lord.
page
18, my lord. It is the order dated 2011-2023.
and that order that rejecting his prayer.
My lord, that is at page 88.
This was challenged before
That was
the.
challenged before the tribunal.
Oh.
The tribunal upholded that order, my lord. And now the order of the tribunal is under challenge. Paragraph 7 also, my lord, page 23. Order passed by the London Tribunal, my lord, at page 23. Tribunal has clearly observed, my lord, that the applicant has already availed 3 spouse posting tenures. And as per paragraph 42 of the ROI, the applicant cannot avail spouse.
Where is that? Where is that?
My lord, page 23. Paragraph 7.
Okay. Heard Mr.
S. Decker.
S.
Decker.
Dekka, learned counsel for the petition. Also heard Mr. H. Gupta, learned CGC, appearing on behalf of all respondents.
My lord.
All the respondents. Stop. Para. Petitioner was appointed as Ayat in the Assam Rifles in the year 1996. And her first posting was at Agartala. The petitioner got married on 14/2/2009. What was posted in Agartala at 9 DUAR in capital. Within bracket, dental unit Assam Rifles. Stop. Where's the last transfer order?
My lord, it
At
is
page
mentioned.
72A, Your Lordship. 72.
Stop. By an order dated 22nd May 2023. The issued by the Director General within bracket Assam Rifles. Recorded branch. Record branch. Within bracket ADM dash Roman 4. Civil. Close bracket Shillong. The petitioner where is this transfer? Was transferred, correct?
Yes, Your Lordship.
To
No, the
fake, my lord.
38 AR, fake Nagaland, Your Lordship. Paragraph 3, Your Lordship.
To 28 AR.
38, Your Lordship.
Is it 28 or 38?
38, Your Lordship.
To 38 AR. Within bracket fake oblique Nagaland oblique heart. Stop. The petitioner thereafter made the representation for spouse posting where her husband was posted at
At HQIGAR, Your Lordship. Silchar.
HQIGAR Silchar. Stop. After considering the representation from the respondents by an order date 4th October 2023, correct?
My lord.
Yes,
Rejected the request for spouse posting with a further direction, with a further advice to apply after completion of normal tenure at present unit for consideration by the competent authority on merits. Stop. Para. Being agreed with the order dated 4th October 2023, the petitioner approached the Central Administrative Tribunal, Guwahati bench, by way of OA number 040 oblique 00350 oblique 2015.
No, my lord.
no, no.
My lord, this is page 18, my lord.
Oh. Huh?
The impugn order, the order is at page 18. The order passed by the tribunal
Oh, sorry.
is at page
Annexure 1,
18.
Your Lordship.
No.
Annexure 1.
You know, approach the Central Administrative Tribunal Guwahati bench by way of original application number
46.
046 oblique 00338 oblique 2023, which was disposed of by order dated 20 November 2023. by making an observation that the petitioner had repeatedly approached the tribunal, challenging posting orders on different occasions. At least 3 times, basically on spouse ground, and retained in the earlier posting, either by interim order or order of the respondents. Stop. The learned tribunal further came to the conclusion that as the transfer is an instance of service, and one cannot enjoy same posting on spouse ground beyond provisions of rules or circulars. There was no merit, and accordingly, the said OA was dismissed. Stop. Para. Being aggrieved with the order dated 20 November 2023, passed by the Central Administrative Tribunal, Guwahati Bench. The petitioner is before this court by way of the present petition. So, para. When the matter was taken up, this court directed the learned CGC to 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 apprise the court whether the petitioner can be considered in any grade for no, whether the petitioner can be considered. What was the query?
My lord, in the instruction, it is quoted, my lord, 5/1/24 letter, paragraph 2. Quoted, my lord,
Whether the petitioner can be accommodated
my lord,
for spouse posting,
considering the
considering the fact that the petitioner is serving as Aya,
yes, my lord.
which is a group 4 post. So, para. Today, when the matter is taken up, the learned CGC has produced an instructions dated 30 January 2024.
My lord, 3 January, my lord.
Okay, 3 January 2024. And the same reads as under. You just got the whole thing. A to A. Yes, I'll flag it. Stop. Para. While taking up this method, were informed that the petitioner had already availed 2 compassionate grounds posting and 3 spouse posting.
Oh, so one compulsory ground post,
Oh, no, 2.
only once here.
You have availed 2.
No, my lord, it is 1 only, my lord.
Page 88, para 6.
Yes, my lord, 2, my lord.
2 had availed 2 compassionate ground posting and 3 spouse posting. And as per para 6 of the ROI 01/2016, an individual can avail compassionate ground posting only once in his/her entire service career, including last leg posting. And whereas request for second CG posting may be considered in case of persons who has completed 30 years of service and availed the previous CG posting 7 years prior to present request. Stop. Accordingly, comma, the request for fourth spouse posting at headquarter IGAR within bracket East is not feasible due to policy as well as administrative constraints. Stop. Learned counsel for the petitioner at this stage submits that the petitioner is suffering from what is it?
Spondylitis.
Suffering from spondylitis. And therefore, as per the advice of the medical officer, District Hospital, Dimapur, Nagaland, the petitioner is required to stay in a hot, warm place. And therefore, a direction will be issued to the respondents to consider the same. Stop. We are unable to accede to the requirement by the learned counsel for the petitioner. And as the petitioner had already availed 2 CG posting and 3 spouse posting, we see no reason to interfere with the order dated 2011-2023 passed by the learned Central Administrative Tribunal Guwahati bench. Stop. Accordingly, petition is dismissed. Stop. However, liberty is given to the petitioner to file an appropriate application on medical grounds if so advised. That is enough, no?
Item 6, 7, and 8 for admission.
My lord, this petition is filed, my lord, for against the government notification, my lord, reducing the grade pay of LP school teacher, my lord. It was the government decision and ROP was, my lord, as per the ROP report, my lord, all the graduate teachers were, my lord, assembled and given the same grade pay of 8,700 rupees, my lord, per month, my lord. Subsequently, by the my lord, decision of the anomaly committees, they have reduced it to 7,400, my lord. That's why we have challenged that notification, my lord. And we have already completed our pleadings part, my lord. Just I want to place, my lord. It is their decision, my lord. Otherwise, case is pending from the last 6 years, my lord. And most of the LP teachers have already, my lord, retired also, my lord. So due to the reduction of the said, my lord, grade pay, my lord, they are not getting enough, my lord, pensionary benefit also. That's why, my lord, it has to be disposed of, my lord. Even our admission stage, my lord. And
Other pleadings are completed from both.
issues,
Then we'll admit it and list it for hearing.
My
Uh,
lord, in fact, my lord, the amendment of the ROP rules have been put to challenge.
Then we'll require some hearing at length.
my lord, date may be given. Otherwise, my lord, it is all 6 years already pending, my lord.
But it's does the counsel for the petitioner. Admit. Who appears?
But I appear for the finance department.
Mr. B. Govel, the standing counsel finance appears for, the standing counsel appears for the finance department. And Mr. R. Majumdar, standing counsel appears for the school education department. Yep.
I am for 7 and 8, Lord.
No, he is in another petition.
Analogous petition 7 and 8, Lord.
In item 6, huh? List the matter for hearing. When do you want?
My lord, we need, my lord, in the hearing, my lord, in the February itself, my lord.
Okay,
Yes, my lord. Issue is very simple.
22nd February.
Yes, my lord. Highlight 26.
In item 8, you write hurt Mr.
AMS Majumdar.
AMS Majumdar. It will be the same, no?
Lordship 7, Lordship item number 7, this is the IA. Lordship, this IA is infractuous in the, this may be closed.
Okay, in the area, Mr.
MS Majumdar.
MS Majumdar submits that the present application has to come in. Mr. B. Google and his standing counsel appears for the finance department. And Mr. R. Majumdar and the standing counsel appears for the school education department. I is accordingly disposed as in practice.
And
In item
Eight is lordship maybe listed along with 6, Lord.
MS Majumdar, commissioners, same order,
Lord.
like item 6, list on.
Ablal.
Item 9. Last year also. My lord, last time also they are not appeared. But my lord, this is a departmental proceeding, my lord, imposing of penalty, and that is been challenged before the honorable by a judicial officer. So, my lord, I have received the record. So I have to file affidavit, my lord. 4 weeks time may be allowed, my lord.
None appears for the petitioner, Mr. T.J. Mandal, and the standing counsel for the High Court. Submits that he has received instructions and prays for 4 weeks time to file affidavit. Praise allowed. List after 4 weeks.
My lord, deep lord.
Item 11.
Lordship, we are supposed to file counter affidavit in reply to medical department. We'll be needing 3 weeks more time if you may kindly grant us.
We have filed the affidavit, there is short for time to file the reply. Against
You want to file reply?
Yes,
Okay, MS,
CNMA,
CNMA, then the counsel for the petition.
the
Praise for
Sana,
how much time?
3 weeks.
3 weeks time to file reply to the counter filed by the
health department, madam. By response number 3.
filed by the respond number 3. Praise allowed. List after 2 weeks. Nothing.
Item 12.
Item number 12, your lord.
Item 12.
Mr. Borpujari appears for the state, your lordship.
Where is he? None appears for the appellants. List after 2 weeks.
Item 13. In this case, lordship, last 2-3 occasions, the lordship has made query to the petitioner to submit on what his maintainability question was there raised by your lordship. Today he is absent, lord.
Petitioner in person is absent. Mr. Novadia, Leonard's standing counsel appears for the irrigation department. Yes, after 2 weeks.
Item 14.
Please, Lordship. Lordship, in this matter, Lordship has already passed similar order. Lordship may take this matter with this. But Lordship. Lordship has already passed similar order.
What
again.
order?
Lordship, in this petition, page 49, Lordship, 49 to 131, of party part Lordship in 139. Appeal against Lordship order dated 6/6/2023, Lordship. Now,
Pending your lordship, will be tagged along with appeal number
What similar order? What similar order? we
Lordship,
have?
Lordship has issued notice to the.
Where is the order?
Yes, Lordship.
Why are you keeping it?
No, Lordship.
Who appears for school education? With April 443,
Yes, Lordship.
you want it to be taxed with it.
Yes, sir.
When is it listed?
15 to Lordship. Yeah.
Hmm?
15 to, it speaks on 15 to.
15
Yes, sir.
of February.
February.
Who appears? You appearing on your good name?
PJ Dutta.
Third PJ Dutta, learning counsel for the appellant.
Edas.
Issue notice. MS
Edas.
Adas, learning counsel. School Education Department appears on behalf of all respondents.
Yes, sir.
All the respondents.
Yes, sir.
On behalf of all the respondents. Issue notice on the prayer for entry. List the matter on the 15th of February 2024, along with writ appeal number 443 of 2023.
Lordship. Lordship, in item number 16 is also similar, Lordship.
Wait, it will be called out now.
Lordship. Oblige.
Here also same,
Yes, sir.
same order. List along with writ appeal so and so, huh?
Oblige.
Item 25.
May I please, my lord? My lord, the order passed by the, my lord, Learned Single Judge, my lord, is under challenge. My lord, before the court below, my lord, we have challenged the order passed by the SLC. My lord, my case was recommended by the DLC, my lord. And the recommendation is
Compassionate.
compassionate, my lord.
Hmm.
My lord, page 29. My lord, we'll see page 29. My lord, that is the recommendation by the DLC. My lord, DLC has recommended my case.
Page.
Page 26, my lord, is the annexure which starts from. That is the, my lord, minutes of the meeting of the DLC for recommendation for of case for compassion appointment on ground of Kamrup district held on 1/3/2017. And my lord, my name is at page 29. Page 29, my lord, at serial number 8, my lord, that is the office of the executive engineer PWD Rongya RR division. And my lord, my name is in the second last column, my lord, Dhaneshwar Parania, my lord, grade 4. Recommended, my lord has got it.
Yes.
And then my lord recommended for grade 4 posts on the strength on their own department. Recommended for grade 4 posts. Now, my lord, thereafter, the SLC sat on, my lord, 31/12/2018. My lord, that is nearly after more than a year. Annexure C, my lord, is the decision by the SLC. Page 39, 31, sorry, my lord. Page 31, Annexure C is the rejection by the state level committee. That is, this order starts from, my lord. Page 33 is the, my name is there, my lord, at serial number 22. And the grounds for rejection is, my lord, not within 5% quota. So, my lord, my contention is that, my lord, when my case was recommended by the DLC, at that time, my lord, there was vacancy, my lord. And when the case was placed before the SLC after more than a year, the SLC rejected it on the ground of 5% quota, taking the vacancy on the date of the SLC, my lord. That is what, my lord, is contrary to the, my lord, one of the decisions, my lord, passed by this court itself. My lord, I am relying on the judgment at page 35. And the relevant portion of the judgment is, my lord, if I may read, my lord, two paragraphs of the same, my lord, starting from paragraph 2. A similar case, my lord, page 20, page 36, my lord. May I read, my lord, page 36? Paragraph 2.
Just go. After 5 minutes.
My lord. My lord, I was at page 36, my lord. My lord, in a similar case, my lord, if I may read, my lord, the father of the petitioner, Mumtaz Ali, who was working as a Khalasi grade 4 at Sukla Division of Irrigation Department at Goreshwar, Buxa, died in harness on 4/8/2016. And on his death, the petitioner submitted an application for compassionate appointment on 22/9/16. The said application of the petitioner was given its consideration by the DLC of BTC in its meeting dated 21/12/17. The DLC arrived at its own conclusion that the total cadre strength of Khalasi in the irrigation department was 63, and therefore 5% would be 4. As 3 candidates had already been appointed on compassionate basis, therefore the DLC deemed it appropriate that 1 vacancy for compassionate appointment had remained. Having identified the vacancy, the petitioner was recommended for a post of Khalasi on compassionate ground. When the recommendation of the DLC was placed before the SLC in its meeting of 15/9/21, it was rejected by providing that 5% quota had already saturated. Now, my lord, this is what I'm relying upon, my lord. We have taken note that the date of the DLC meeting was 21/12/2017, whereas the SLC meeting was on 15/9/21. The legal requirement of the SLC is to consider a vacancy position as evaluated by the DLC on the date of its meeting, not when the SLC would take up the matter, which in the present case is after 4 years. It appears that the SLC has misdirected itself and accordingly took the vacancy as on 15/9/21 when the SLC meeting was held. In view of the infirmity and aberration of law, we set aside the rejection by the SLC in its meeting dated 15/9/21 in respect to the claim of the petitioner, who was recommended by DLC on 21/12/2017. So, my lords, I am relying on the, my lord, same point. My lord,
Was this placed before the single judge?
my lord, connection has been. It has been. My lord, this was annexed, my lord, before the learned single judge. I am reading from the annexure only, my lord. I have annexed the copy of the writ petition, which was annexed, my lord. Next number to complete. Yes, my lord, it was annexed, my lord, in the writ petition. The order dated 21/9/22. My lord, my case is also similar, my lord, because here when the DLC recommended my case, my lord, there was a vacancy. And when the SLC took up the matter, my lord, it cannot say that, my lord, 5% vacancy is not there, my lord. So this is my lord, ground for challenge, my lord, because the SLC should take into consideration, my lord, the recommendation made by the DLC, and my lord, that would be contrary to what was already recommended by the DLC. My lord, this is one ground, my lord. And the second ground is, my lord, that the ground of, my lord, clause 15 of the OM. So it will say. My lord, even if the vacancy is not there in grade 4, my lord, in terms of the office memorandum, my lord, the department has to explore the vacancies in any, my lord, the or other departments also. That is, my lord, paragraph 15 of the OM. Copy to dear. But my case is governed by this office memorandum dated 1/6/2015, which is relating to compassionate appointment. And my lord, at paragraph 15 of, my lord, page number 6, my lord, at the bottom, my lord, it is reflected. Page 6, paragraph 15. It will go in. It will- Paragraph 15, my lord, if I may read, my lord. If sufficient vacancies are not available in any particular office to accommodate the person in the waiting list for compassionate appointment, it is open to the administrative department office to take up the matter with other departments of the government to provide at an early appointment on compassionate ground to those in the waiting list, my lord. My lord, on these two grounds, my lord, we have assailed the order, my lord, passed by the Learned Single Judge. Because, my lord, once the DLC has stated that there was a vacancy, my lord, SLC on the contrary cannot, my lord, reject it by saying that 5% quota is fulfilled.
Where the single judge order?
My lord, it is at page, my lord,
is relevant for.
page 38, my lord, it starts from. And, my lord, page 40 is the part, my lord, which we are assailing, my lord, this second last paragraph. Page 40, my lord, the second last paragraph. The aforesaid fact, coupled with the delay in approaching this court, would demonstrate on the face of the record that it is not a fit case for this court to interfere with the minutes of the SLC dated 31/12/18, which had rejected his application for the want of vacancy under 5% quota. My lord, the issue of this 5% quota, that was under challenge, my lord. Before the, my lord, court below, my lord, which was not addressed, my lord. I'm relying on the other judgment, my lord, which I have just now read to support my contention that, my lord, the 5% rejection by the SLCs would be contrary to their own stand, my lord.
Oh, take it.
No.
Yes.
Lordship, first of all, this technically defective because and all annexers given in the repetition, he has not annexed in the writ appeal, number one. Number two, Lordship, he has challenged the SLC after 4.5 years, which is single judge has rightly pointed out, Lordship, in page 39, Lordship. After a lapse of nearby 4.5 years from the date of rejection of his prayer by the SLC, the instant writ petition has been filed. He has not explained the delay also. Lordship, number three, Lordship, he has challenged the SLC by saying that another writ petition has been filed by one Dauharu Bosumotari was allowed by the petitioner, and the same honorable single judge dismisses petition. Dauharu Bosumotari's case is totally different. He was his post was considered a grade 3 post, and remarks, Lordship, ground of rejection, 5% quota already filled up, and number two, underqualified. He has not read that underqualified point, Lordship, because of that, honorable single judge has directed to consider him as per his qualification. It is the separate case, Lordship. It is not similar, Lordship. And Lordship, single judge has rightly rejected his case on the ground of delay
delay, Lordship, because all that posts were already filled up. Only 5% quota is given for compassionate appointment. Compassionate appointment is not a right, Lordship. It is only compassion. He has survived since 2015, now 2023, 24, Lordship. So many years has been elapsed, Lordship. Otherwise, Lordship, new generation will suffer, Lordship. Compassionate appointment means immediate relief, Lordship. Somehow he has managed to survive since 2015, Lordship.
You have not annexed all the documents.
We have annexed, my lord, this is a wrong submission, my lord.
No.
My lord, will see page 15, my lord, is the
Annexure
index,
repetition
my lord,
or
page 15.
Read petition or annexure can be done.
All the annexures we have annexed.
No, read petitions annexure. All the read petitions annexure.
No, we have annexed.
Oh, tomato to nine.
Page 20, it is up to page 22, my lord, annexure D. And page 37 is the up to that writ petition. All the annexures are annexed, my lord.
Annexure repetition. Then also, Lordship, he is approaching this honorable court, challenging the SLC after 4.5 years, Lordship. How can it be possible for now to keep that post vacant?
For appointment of on compassion ground has to be with that person. The cases which is relied is the DLC is clearly
When
said
fifteen,
that it is equal
when
to
fifteen,
both
when
and then
when
make this
fifteen,
equal.
what is it? One fifteen.
Please.
We are not conversing. Selection process too. Yes.
Clearly, the DLC said that it is within 5%. That is there. This is at the time of consideration. It will be has to be determined by the identified by the DLC only.
What is the issue of underqualified? You said
No.
that
Underqualified in earlier, he has relied on similar case.
No, no, that judgment I have not read. That is a different judgment which may limit me. अपनी मुझे तो पढ़ा ही नहीं.
But he has annexed Dauharu Bosomotari's case.
No, that is, but I have not submitted on that, my lord.
Annexure, Lordship 41. Annexure 3 place 41.
See, Gupta, there's a difference in the judgment that you have relied upon in the present recommendation made by the DLC.
My lord.
Here, the DLC has said recommended for grade 4 post from the strength of their own department.
My lord.
All right.
Hmm.
In that writ petition, DLC has clearly specified the 5% quota.
My lord.
Now, how do we know that this is within the 5%?
Lord, here also it was on the own department, my lord.
Of their own department, on the strength of their own department.
Yeah.
How do we know that it is within 5%?
No, normally, my lord, there are two ways, my lord. Normally, they reflect in the chart, my lord, 5%. My lord, it is only at the stage when the SLC, my lord, takes up the matter for the appointment, my lord, that percentage is shown there, not at the time when the DLC is considering. When the DLC is considering, my lord, it is presumed that, my lord, when the case is recommended, my lord, I am recommended against that particular vacancy. Now, my lord, if the SLC sits after 4 years, my lord, that cannot be, my lord, should not deprive the person, my lord, because that will be already that person has been recommended against that post. And normally, my lord, in terms of the office memorandum, normally the vacancy should be filled up within 6 months. These are not been followed by the department, my lord. I have filed an application for compassionate appointment on 1/5/2015, which was taken into consideration by the DLC on 1/7/17. And then, my lord, the SLC takes it up on 31/12/2018. The office memorandum dated 1/6/2015, my lord, contemplates that all the vacancies against the quota for compassionate appointment must be filled up within 6 months from the date of occurrence of the vacancy. My lord, once I have been recommended by the DLC, my lord, SLC, when it sits after a prolonged period of time, my lord, it cannot take the vacancies at that point of time.
Well, you'll have to,
I know.
Lordship,
you'll
we
have
have-
to satisfy this court.
Lordship.
Whether the rejection by the SLC was, that it was not within the 5% quota. Was it completed on the date that the SLC set or on the date the DLC made this?
Lordship, normally, what happened, Lordship?
No, not
though-
normally, you'll have to be sure.
Lordship, I shall take instruction on that, Lordship. Normally, what happened, Lordship, though we have lapses to teach SLC, like, but we consider for that period only, Lordship. So I shall take instruction in this regard. Which year this case is rejected?
And that 5% quota, when it was it on the day the SLC set?
When it was considered on by the DLT.
Mr. H. Gupta, let it counsel with the appeal. MD Bora, then it's government.
RB,
Sorry, RB Bora, then the government.
1 and 3.
Appealing for the respondents, 1 and 3, shall take instruction as to whether the 5% quota, 5% reservation for compassionate grounds was considered by the DLC on the date, as on 31/12/2018 or 1/3/2017, i.e. the date when the DLC made its recommendation.
Applying for response 2, 3, and 5, Lordship.
And
Lordship P. Barua on behalf of Mr. P. Nayak.
Must be Barad, Learned Council appearing on behalf of P. Nayak, prayers for respondents.
Lordship 2, 3, and 5.
2, 3. How much time you require?
Lordship 3 weeks time, Lord.
This is the matter of the 3 weeks.
If you wish. Extra copy is upon us today. itself.
Yeah.
If you-
Item 27 for orders.
Service on the respondents had been deemed to be complete, my lord. On the last occasion, since they had not appeared, some of the respondents, lordship had given them an opportunity to appear.
Are you appearing?
No, my lord, I'm not appearing for the respondent for whose the paper publication is made, my lord. I'm appearing for few of the respondents.
You file your objection?
No, my lord, I have but not filed the written objection in this matter, my lord, but there is a, my lord, this review was dismissed on 39/2015. And my lord, as per the explanation on 17/5/2016, there is an opinion to prefer the appeal, my lord. So there is although some explanation, but no proper explanation for about a year, my lord. So that is my objection.
So you want to file your objections or you just want to give an oral submission?
Lordship may record my oral submission, or Lordship may grant me 2 weeks time, I will file my written objection.
Right, R. Majumdar, then it's standing council, school education department. For the appellants. Mr.
A.K. Gupta,
A.K. Gupta, then council appearing on behalf of,
I will write down the respondents' numbers.
on behalf of, give the numbers.
Yes, I will write.
Press for 2 weeks time to file objections. Press allowed, list up to 2 weeks.
Okay.
List. 28.
Yeah, please, Your Lordship. Lordship, this matter first pertains to non-release of retirement benefits of the father of the petitioner. In this matter, Your Lordship.
Please, Your Lordship, I'm sorry. My Lord, I somehow it escaped my attention. My Lord, I will pray a short adjournment for filing a affidavit because there has been subsequently development. A civil suit was filed in regard to some of the issues that has
Sorry.
not been pursued and dismissed. There was a counterclaim also. We'll bring it on record, Your Lordship. Will give us some time, my Lord. Around 4 weeks, my Lord. We'll have the certified copy and bring it to the notice of this court.
Okay, heard, Mr.
SK Chakma.
SK.
SK Chakma. My name is not there. I am appearing on behalf of Ms. D. Ghost.
Let the counsel appearing on behalf of MSD Ghosh, then the counsel for the petitioner. Mr. BD Conward, and it's senior counsel. Praise for how much time?
My Lord, let it be on, my Lord, 18th of March.
Okay, on request made by Mr. BD Conward, and it's senior counsel. For the respondents,
Yeah. Respondent number 3.
for the respond number
3.
3. List down. When do you want? March?
18th or এরকম type হবে, I don't know.
18 March.
এটা লিখে রাখো। 29
Deeply obliged.
Please, Your Lordship, this IA is for my lord stay of the impugn order, my lord.
Have you taken steps?
Matter is pending since September 2022. We have taken steps by Dasti twice, my lord. Recently we have taken steps, that is on 9/1/2023, my lord. But the respondent number 4 refused to accept, my lord. So far as the other respondents are concerned, my lord, service is complete, my lord.
Respondent number
4, my lord. We have also filed affidavit on 18/1, my lord.
So how do we know that he refused to take?
My lord, it has been returned, my lord. I have stated in my affidavit, my lord. I have filed affidavit on 18th, my lord. It is in the record.
That we are on the.
In the affidavit, my lord, we have also, my lord, annexed the receipt also, my lord.
Where is it shown that it is not accepted?
My lord, at page, my lord, I have stated in my affidavit at page.
That
Page
your
3.
statement is there, but then there should be some witness. Because it is by way of Dusty.
Witness was there, my lord, but.
Then
I
where's
have
the
not,
no,
yes,
where's
my
the
lord.
signature of the notice saying that the respondent for refused to accept notice?
My lord, the petitioner went to, my lord, serve the Dasti along with witness, but his signature is not here, my lord.
That's what the, how do we know? How do we know?
Because I have filed this affidavit, I am swearing this affidavit, my.
Maybe you're sharing the affidavit, but how do we know that he has refused to accept? There should be some witness. At least the witness should have signed saying that he has refused to accept in my presence.
Yes. Then I may be allowed to file another affidavit, my lord. So that I
Okay, on
can,
request made by Ms. S.P. Chaudhary, legal counsel for the appellant. Release after 2 weeks, 1 week,
1 week, my lord.
after 1 week.
Item 30.
Like,
Yeah, please, Your Lordship. So, when in this matter, the affidavit in opposition has been filed by the respondent side, my lord. I'm praying for 2 weeks, 3 weeks time, my lord, for filing my reply, my lord.
Filed by respondent.
Respondent, my lord, the official respondent as well as private respondent, my lord. Both of them, my lord, filed there.
Okay, Mr.
User sake, yeah.
You just cycle and counsel for the petition. Where's for how much time?
3 weeks time.
2 weeks time to file reply to the counter affidavit filed by the official respondents as well as the private respondents. Stop. List after 3 weeks. 32. Oh, don't say like that. Fine, perfect. Okay.
May please.
1 minute. Place for 3 weeks time, huh? To file affidavit to the counter affidavit filed by the respondent number 5 and respondent number 6. Yes.
My lord, in this case, the service is complete. The respondent, sole respondent has appeared.
I'm representing the sole respondent. So, my lord, matter may be taken up for admission.
Okay, heard Mr. Ganguly, learned counsel for the petitioner, for the appellant. Mr.
S. Chakravarti.
S. Jagavati, learned counsel, appears for the sole respondent. Stop.
Can it be on 30?
List
Lord,
for-
before my, Lord, there's an IA, my lord, that I have filed. There's 2 documents. What has happened in this case, my lord, that notice of motion was issued. Records were called for. My lord, the writ petition was disposed of on the basis of records. There are 2 documents, my lord, I have filed along with the writ appeal. Since I could not file the affidavit in opposition, there was a change of counsel also, my lord, in that matter. My lord, I crave leave to file, to rely upon those documents, 2 documents. Learned friend, if he wants to object, he can file objection, or else, my lord, that can be.
I have not received that. You can give me a copy of that. I don't have that IA with me. I have
My
not
lord,
received.
this is IA Civil 1992 of 23. I'll give my lord friend a copy, no issue.
Okay, then you do one thing. Heard Ganguly, learned counsel for the appellant. Also heard Mr. S. Chakravarti, learned counsel for the sole respondent. Learned counsel for the appellant shall furnish a copy of the IA number 1992 of 2023 to the learned counsel for the sole respondent within the course of the day.
Lord,
List after.
My lord, can it be on 9th of February?
List on 9th February.
Public.
Item 33 and 34.
What will take up my IA 89 of 2024, wherein I have prayed for tracking of the names of the respondent of 5 and 7 from the area of parties.
And
They
what is item 33?
And 33 is the, I find an appeal, there is a limitation, there delay of 107 days. No, sorry, 307 days. Possible was track of the name of the respondent of 5 and 7, because after filing the appeal, Malad, it has found that these 2 persons are not working in the institution.
Do you want to strike off the
Strike
name
of these 2
in the IA?
in the IA.
IA number 1769.
Lordship.
Respondent number
5 and 7, Lordship.
Give me that IA. Yeah, okay, 89. Yeah, who appears from the other side? I will.
I am appearing for the private respondents here.
You have
1,
any
4
objection for striking of the name?
Yes, 5 and 7, they are not working in the department now. I am appearing for respondent number 1, 2, 3, 4, and 6.
One minute. But Mr. S. Bora, then the counsel for the applicants in IA 89, by this application, the applicants are praying for striking of the names of the respondent number 5 within bracket Prasenjit Devnath and respondent number 7, Praveen Kumar Gupta, as respondents 5 and 7 in IA number 1769 of 2023 on the ground that the said respondents 5 and 7 are not working in the department, isn't it?
It is ITI Salagati.
In the are no longer working at ITI.
ITI Salagati.
Salakati. Stop. You have any objection? No.
No, well.
No. After hearing the learned counsel for the parties, the prayer is allowed. Stop. I is disposed. In I number 1769, in view of order passed to the I number so, let the respondents, let the names of the respondents
5 and 7.
5 and 7 be struck off from the area of respondents in the present IA. The applicants are directed to file amended cost title within 1 week.
Lord.
1 week. List after 1 week.
The date may be flexible, dear.
1 week.
But it's a long pending case.
List
First week of February.
Second.
Second of Obliged.
Much obliged.
Item 36.
Wait, is lordship. This is a leave petition, my lord, praying for allowing the applicant, my lord, to prefer the connected appeal. The third party appeal, my lord, she was not a party in the writ proceeding. What happened, my lord? She filed a writ petition before this honorable court, whereby she, my lord, challenged the B.Ed degree of the private respondent here in my lord, on the ground that her B.Ed degree is not valid, as it was not recognized by the NCT. That writ petition is pending. On the basis of that, my lord, there is an interim order operating. Now, my lord, in the impugn order, the learned single judge has held that, my lord, held that order passed by the Commissioner and Secretary, Education Department, to be illegal, whereby indirectly it was held that, my lord, her B.Ed degree is valid. If that judgment remains, my lord, it will have bearing on the other writ petition which is pending before this honorable court. And my lord, this writ petition,
we don't understand what you're saying.
My lord, in the present appeal, my lord, in the present appeal, the order impugned. Thereby, in that order, my lord, the learned single judge held that her B.Ed degree is valid.
Who's
the private respondent, my lord, Gita Sridas. Gita Sridas. Her B.Ed degree has held to be valid. And if that order remains, the other writ petition will become infractious.
Why?
Because, my lord, I have challenged her appointment as in-charge principal on the ground that her B.Ed degree is not valid. And on the basis of that, my lord, an interim order was passed by the honorable court, that order is still operating. That one aspect, my lord. Another aspect is, my lord, this writ petition was decided along with another writ petition, my lord, analogously, by the common judgment. In the common judgment, the other writ petition was challenged before this honorable court by way of writ appeal. In that writ appeal, my lord, there is an interim order passed by this honorable court.
The Lordship has passed that interim order, my lord. This, the judgment is already under challenge in another writ appeal, my lord. But by the other party, my lord. So, my lord, leave may be granted, let the appeal be heard on merit, my lord, along with that appeal, my lord. Mr. Bailey.
May I submit, Lordship? Lordship, I have filed a detailed objection with regard to submission. Lordship, what happened in this case? The writ petition which he has filed, that is not challenging my appointment. And the writ petition which has been decided, the appeal which is under challenge, that was a writ petition between one Gita Sri Das and one Bijan Nath. They have participated in a regular selection process of principal in the year 2017. She was not even a participant in the state selection. She was an outsider. She is only an incidental beneficiary. She was appointed as in charge only for a particular period of time. And her appointment was also, she was also removed from the post of in-charge principal. Lordship, the writ appeal, Lordship, the order passed by the Laran Singh Judge is between the petitioner, Gita Sri Das, and one Bijan Nath. And in the meanwhile, he has already there. Thereafter, after 4-5 round of litigation, Lordship, this honorable court has held that my B.Ed degree is valid. And that is also on the basis of a writ appeal judgment, which I have annexed in my objection. Lordship, may kindly see writ appeal 154.
Are you filing a reply to this objection or not?
My lord, perhaps reply is not required, my lord. Lordship will kindly turn to page 24 of my IA.
That's fine. If you don't want to reply, that's all right.
Page 24.
24.
Page 24 of my IA, my lord. This is the petition filed by the petitioner applicant. Page 24 of my IA, my lord.
Lordship, I am referring to page 145 of my objection.
1 minute, 1 minute.
Page 24, my lordship got my annexure 8, my lord. The petitioner is Rita Rani Roy, the applicant here in my lord. And respondent number 5 is Gita Sri Das. Gita Sri Das. The interim order lordship will find the operative part. My lord, page, it starts from page 25, my lord, and operative part will be page 26, my lord. Second paragraph, my lord. By placing a communication of the Commissioner Secretary to the Government of Assam in the Secondary Education Department, number so and so, Mr. Soikia, learned counsel for the petitioner, apprised that the B.Ed degree obtained by the said respondent number 5 from SB Institute of Education, Hailakandi, is not a valid degree approved by the NCTE. And that order passed 24/1/2020 order has been set aside in the connected appeal. The order impugned in the appeal. So, my lord, this will have bearing on my writ petition also, if that order remains. Lordship has got it, my lord. If my friend has to make any objection, he can make objection in the writ appeal also, my lord, instead of raising objection in the IA, my lord. Her appointment as in-charge principal has been stayed by the Honorable Court, my lord.
Yes.
So the entire issue is with regard to regular selection of principal between Gita Sri Das and Vijaynath. Our claim is only for the post of in-charge principal. Now, Lordship, the entire issue has been decided by the division bench. And on the basis of the division bench order, Lordship, the single judge has also passed the same order. That because one Govinda Sargoparty's case was decided in the writ appeal 154, and we belong to the same batch, 96, 97 from Shashi Bhushan Institute of DED Education, Lordship. So same batch, same, that issue has already been decided. Lordship, may kindly see page 91 of my objection. The first writ petition, Lordship, filed in 2017. At page 93, Lordship, 2706. 2706 2017, that is Gita Sri Das, petitioner, and Lordship will come to the private respondent is one Vijaynath, respondent number 7, page 94. This has been decided in my favor. His master degree was set aside. Postgraduate degree obtained from Sam Higginbotham was set aside. Then they carried this order into appeal at page 108.
1 minute. Yes.
Then page 104. Vijaynath, he filed a writ appeal 55 of 2019. And the private
1
respondent.
minute. What did the single bench say?
Single bench held that the postgraduate degree obtained by Vijaynath is not a valid degree from Sam Higginbotham Institute of Agricultural Science Law. And the appointment of Vijaynath was interfered with, and the department was directed to take a call on my appointment because I was the second in the empanel list. Thereafter, the Vijaynath Lordship filed a writ appeal at page 104. It was dismissed at page 113, Lordship, by upholding the order passed by the learned single judge.
Yes.
Thereafter, Lordship, at page 114, Lordship, there was a review selection, and the review selection, Lordship, my name was approved. At page 114 is the forwarding letter, and 1115, your Lordship will find in respect of Kasar, Lordship. Page 115, Lordship, the of my objection, Lordship. In respect of Swarna Lakshmi High Secondary School, similarly Gita Sri Das in the right hand column, Lordship. Gita Sri Das is recommended for the post of principal of Swarna Lakshmi HS School, as per Honorable Court's order dated so and so, WBC so and so, and speaking order is issued. Thereafter, Lordship, that order was not complied with, Lordship, and I filed a contempt. In the contempt, Lordship, in the commission and secretary passed an impugn order, page 116. Because it was in the initial thing, Lordship, held that my BEd degree is not valid. Thereafter, I challenged that order of the commissioner and secretary in WBC 1740. And this honorable court has passed an interim order, Lordship. May kindly see at page 119. Accordingly, it is directed in the meantime, the post of principal of Swarna Lakshmi High Secondary School, Narsinghpur, Kasar, to which the petitioner had been recommended for appointment, shall not be filled up on regular basis without the leave of this court. So my interest was protected by an interim order. Thereafter, this writ petition was finally decided Your lordship will find the judgment, or your lordship has already seen the judgment at page 123. The authoritative part is lordship at page at page 144, lordship. Two writ petitions were decided together, lordship. WPC, my writ petition was WPC 1740, is to be given the benefit of allowing the writ petition, whereby the order dated 24/1/2020 passed by this department is held to be invalid and accordingly set aside. Now the commissioner's order has been set aside and my B.Ed degree is held to be valid. And this order has been passed in terms of a division bench order. Lordship, at page 145, page 1. The same issue was decided in respect of the batsmate of the petitioner, lordship. There are three incumbents, Govinda Chakraborty, and the learned Singledas has also observed.
Yes.
So all this previous litigation is between Gitastri Das and one Vision Nath. She in the meanwhile has retired. She is only an incidental beneficiary for a particular period of time. She was appointed as in-charge principal. But my interim but I was protected by interim order. No regular principal should be appointed. That has been directed by the Honorable Court. Now, lordship, they have processed my regular appointment. Now, again, just to delay, a third party has come for interference, lordship. Does not have any locus because she has not participated in the regular selection process of principal because she was not even eligible at that point of time. After 2017 litigation, lordship, this final order has been passed. My B.Ed degree has held to be valid, and that too in terms of the division bench order law. She does not have any right or any locus, lordship, because this is for the post of regular principal. I have participated in the regular selection. She has not even participated in the regular selection process of principal. She's only in charge.
Did you participate?
No,
No.
Then?
My issue is that my lord, her degree is not valid. If her degree is held to be valid, my lord, then it will have, my lord, impact in my writ petition also.
No,
And
but
in,
it's
on the other
already-
hand,
It's already settled.
Yes.
Division
that,
bench has upheld it.
that judgment has been, my lord, stayed by the Honorable Court, my lord. The status quo was directed to be maintained, my lord. The judgment relying on which my friend is arguing, the judgment those will find at page 28 of my IA, page 28.
No, just.
Page 28, my lord, it starts from page 28. That is Musabbir Ali, Lordship has got it, my lord. Musabbir Ali, next page, Lordship will find Gitastri Das. Both the cases were decided together. In the Musabbir Ali's case, there is a status quo order passed by the Honorable Court against the same judgment, my lord. Basing on which my friend is, my lord, asking for promotion. Already there is a stay order, my
lordship. That is Musabir Ali. That is between Musabir Ali and
that will
both of
go.
them. And lordship may kindly see Gitastri Das versus Vision Nath. She is not there in the picture, lordship.
Same issue was there. Same issue was there.
Because they were participating in the regular selection process. Both lordship Musabir Ali and lordship Mofaruddin were participant in the regular selection process. But in my case, lordship Gitastri Das and Vision Nath, she was not a participant in the regular selection process. She's an outsider, lord.
What I am submitting, my lord. If one petitioner is allowed to be appointed as a regular principal, and the other petitioner is not allowed to be, my lord, appointed as a regular principal, that will, my lord, have some
No,
complication.
no, no. This is a process for appointment of
Regular
Yes, my lord.
regular
Yes, my lord.
promotion,
Lord, sir.
regular
In
principal.
both the cases,
But you did
issue
not
was,
participate in that process, isn't
Yes.
it, for the regular principal?
I am not
Yes.
claiming that I should be appointed as a regular
So
principal.
what are you claiming?
No, I am claiming that her B.Ed degree is not valid. That's my lord, this honorable court may hold that, my lord, her B.Ed degree is not valid. In the only issue was, my lord, in both the cases, whether their B.Ed degrees were valid or not. That has been decided by the learned single judge in their favor. That has put to challenge in the writ appeal by Musabbir Ali. In the Musabbir Ali case, Lordship has granted interim order directing the parties to maintain status quo. And if she is appointed, that will go against the status quo order passed by the Honorable Court, my lord. Issue is same, my lord. In my writ petition also, where I have challenged her appointment as in-charge principal, there is also, my lord, I have challenged her appointment only on the ground that her B.Ed degree is not valid.
Lordship, the status quo order passed in Musabir Ali's writ appeal, as I have been told, Lordship, that is pertaining to Balesar High Secondary School. But my school is a different school it is a Sasi Sonolasmi High Secondary School. Two separate writ appeals have been filed.
It is
In
their
that
case
first writ appeal, that
that
is between Musabir Ali and
Gitasri Das and Mafuruddin, in the private respondent in other writ appeal, my lord, Gitasri Das and Mafuruddin, they obtained the B.Ed degree in the same base, from the same college. From the same college. If the degree of Mafuruddin is not valid, then how can the degree of Gitasri be valid, my lord? My lord, my prayer is that, my lord,
Supposing her degree is found to be invalid,
my lord,
will you have any claim? Will you have any right for appointment?
I will be working as the in-charge principal, my lord. And the post will be advertised. I will participate, definitely.
Okay, we take up it too. Yes.
Because, my lord, this will have bearing on my other petition also. Oblige, my lord.
that she also played by
Who's
B. Bhuya. Senior comes B. Bhuya over there.
We can't keep on waiting. We'll adjourn it to some other day. But it's Islam learned I'm just curious. As the learned additional PP is not present today. List the matter again on. Do I have it on second? No, second. Oh, February. 2nd February. First,
My lord.
consider whether you Mr. I cycle in the council for the applicant. Please, for how much time?
2 weeks time.
2 weeks time. To file reply to the objection filed by the respondents. Praise the Lord. Least of the 2 weeks. Mr. Ayala, then the council appears for the NCT. And
I'm for respond number 7 NCT.
you have for
I'm paying for the School of Education, Your Lordship. Secondary department.
MS?
ADAS.
Yes, then standing council appears for the school education.
Item 37.
That this matter, I was seeking modification and any other appropriate orders, my lords, in the interest of justice. My lord, this pursuant to direction by the Honorable Division Bench, my lord, CPWD has already taken measurement. And that has to be submitted before the authority. Now, my lord, there's
So
a
what is this IA for?
IA was for, my lords, there are two IAs. One is for modification of an order, modification or any other appropriate order passed of an order dated 28/9/23, whereby direction was given to conduct a valuation exercise and submit a report before the arbitrator. And if in case of it submitting before the arbitrator, there was a interim order which would stood automatically vacated. Now, my lord, the hurdle is the Assam government, my lord, abolished the office of the arbitrator. Now a new proposal has been sent. Now, my lords, this project has been stopped from last April. And now, my lords, now pursuant to direction by the honorable court, my lords, the CPWD has done the measurement exercise. They have to submit a report, my lord. And also this IA is also for, my
But
lords.
before we take up that IA, then this other IA will have to be considered first, isn't it?
Yes, my lords, that it was two IAs were there, my lords. One is 3773. And another is, my lords, that it was for implement, my lords.
Implement. That
Yes,
implement
implement
will
is-
have to be considered first.
Yes, my lords.
After that only we can do.
Yes.
I'm paying for respond number of the part number 1, 2, and 3, 4. So, last question, the issue regarding maintainability of the IA is questioned, madam.
No, that issue will come, but let the implement be done first.
So implement, my lords, as regards, my lords, to complete, my lords, the Principal Secretary Kabi Anglong, along with Joint Secretary Revenue, which is the competent authority for land acquisition under Highways Act, my lord, Kala.
But Mr. D.
Lord, I'm appearing for Karbi Anglong Thomas Council. Lord, IA number 93/24. This is for implement, Lordship. This IA, it is a last time they have second time, Lord. Whether this IA is maintainable or not.
No, that was
On
regards that
issue of-
9773, parent IA. This is something implement.
This is for implement only.
Yes.
So you have any objections in the implement?
No, Lordship, but the issue is whether maintainability.
That is in the other IA. So let us first have the implement first.
That music I will face.
But the Google and the concept of the applicant. This is in IA 93. By this application, the applicants are praying for implement of the Principal Secretary, Karpi Anglong, Autonomous Council, and the Joint Secretary within bracket Revenue, Karpi Anglong Autonomous Council as pro forma parties, opposite parties, number 7 and 8 in IA within bracket Civil number 3773 of 2023. Stop. Who appears? You are praying for?
I'm paying for, my lord, opposite number, my lord, 1, 2, 3, 4, my lord.
Mr.
G. Alaba.
G. Alam, then the council appears for respondents 1, 2, 3, and 4. And Chief Engineer, CPWD,
5 and 6, Mr. H. Gupta.
H. Gupta, Leonard CGC, as well as for the respondents. 5 and 6. Stop. Para. Learned Council applying for the respondents, there's no objections. Full stop. We have also considered the cost shown in the following application and we are satisfied. Accordingly, the prayer for implement is allowed, I has disposed. And in I number 3773, you write, in view of the order passed today and so, let let the principal secretary Karbi Anglong Autonomous Council and the joint secretary within bracket revenue Karbi Anglong Autonomous Council be implemented as pro forma party number 7 and 8 in the present application. Stop. You enter appearance?
Yes, Lord.
Mr.
R.S. Ronghang.
R.S. Ronghang, standing counsel.
Yes, Lord.
KAC. Enters appearance on the newly implemented respondents, pro forma opposite parties, 7 and 8. Applicant directed to file an amended cost title within a period of 1 week. Please, after 1 week.
Always.
38.
May I please, Lordship? Lordship, this IA is filed for condemnation of delay of 34 days, Lordship.
Who appears for the other side? You have any objection? But Mr.
D. Borua.
D. Barwal and counsel for the applicant. Also heard them as ADAS, Learner Standing Council, School Education Department. For all the opposite
Yes.
parties, stop. By this application, the applicant is praying for condonation of 34 days delay in filing the connected rate appeal. We have perused the cost shown in the present application and we are satisfied. Accordingly, delay of 34 days is condoned. 34 days in filing the connected rate appeal is condoned. I is disposed. Registry is directed to number the writ appeal and list the matter in its usual course.
39.
Bad case, Your Lordship. This appeal has been delayed by 8 days.
Who appears on the other side?
Actually, today none has appeared.
Then notice has to go whatever it is. But Mr. A. Das Gupta, then senior counsel assisted by MSA Bhattacharya, the counsel for the applicants. Issue notice. Actually, 8 days notice need not go, but then the other side may come with the complaint that they were not given notice. The applicant to take steps for service of notice on the sole opposite party by registered post AD within 1 week. Least after 4 weeks.
Item 44.
My Lordship, my lord, this is the I have filed for the purpose of implement. My lord, the reason behind it that, my lord, basically, this PL has been taken care of by the Honorable Court suo motu, conferring the certain rights which has been granted, my lord, under different jail members, others, to the prisoners, my lord. Now, Lordship, I have also certain information which are otherwise required to be incorporated in this thing, and that will help to, my lord, assist to come to a right adjudication, my lord. Now, Lordship, can you see for a moment? Order dated passed by this Honorable Court. 15/12/2022.
In the
15/12/2022.
the PIL.
Yes, my lord, that is in I think there are a lot of tech matters are there. My lord, I would like to implement in my lord WPC number Sumoto 8/2018, my lord. My I is 8/2018.
Here.
Therefore, lordship, if lordship allow me to suppose implement, my lord, it will,
Whom do you want to implement?
my lord, myself, my lord, to be the part of as an intervener, my lord.
The petitioner in person wants to be implicated as the petitioner number 2 in the Somoto PIL. But this is a Somoto PIL. I have objection to that.
This is a Somoto.
This is a Somoto
my lord, no doubt.
PIL.
With petition.
My it's
In the writ petition Somoto. In the writ petition Somoto.
it's a WPC, my lord, Sumoto, but basically, my lord, if you see the contents and other thing, other PR has also been interconnected there with, my lord, the issue is pertinent to, my lord, jailers, my lord, jail prisoners' rights, my lord. If lordship allow me, my lord, then
But
definitely,
this court will take care of that.
then lordship, I will withdraw, my lord.
Petitioner in person. Request for withdrawal of this present IA. Accordingly, Mr. D. Nath, London Senior Government Advocate, appears for the
In the I am not for the opposite party number 1.
for the opposite party number 1. I is accordingly dismissed and withdrawn.
Well,
I'm 42 for hearing. Forty-two.
I please the lordship. My lord, we were supposed to produce the record, my lord. And we communicated to Director of Elementary Education, my lord, for record. But yesterday we have received a letter stating that these records are with government. So, my lord, we have to sort the record to secretary to the government of Assam, my lord. So we need some more time.
Okay, Dr. R. Sharma.
Lordship, even in absence of the records, your lordship, the matter may be disposed of. Because your lordship, I was allowed to work till February 2020. I was till retirement. There is a record of the attendance
There's
register.
already a judicial order calling for the records. So
That's right, your lordship.
let us give them one more chance. MS Kedas,
Could it come on 1st of February, your lordship?
Colonel Standing Council, Elementary Education Department, request for further time to produce the records. List on when? First,
Oh, my lord, this there is holiday, my lord, 22nd. 15th, my lord, 15th of
15th.
Earlier, a bit earlier, your lordship.
12th. 12th February.
Obliged.